You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 104, How to Write a Patent Cease and Desist Demand Letter and What to Be Careful of. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's DIAMENT patentlaw.com, or call me at 424-281-0162. In the last episode, I talked about a general overview of patent litigation, and that it usually starts with a demand letter, which is also called a cease and desist letter. Technically, you can demand whatever you want and not have someone cease and desist, but probably what's happening is that someone is selling a product that you believe is infringing your patent, and you want them to stop. Now, maybe you don't want them to stop, maybe you just want them to pay a royalty, and that's fine, but if they aren't going to pay you a royalty, you do want them to stop. So it's really a type of cease and desist letter. So I'm going to go through a sample cease and desist letter. There are all kinds of strategies on how forceful you want to be. Do you want to be really aggressive and say upfront that you're going to sue them? Or do you want to be more friendly so you can enter into business negotiations with them on good terms? It really depends on the situation. So I'm going to go through one kind of cease and desist in this episode. I'm assuming you're doing this yourself. But in all honesty, if a company gets a cease and desist letter from an individual inventor, it's not going to be taken as seriously as if it comes from an attorney. So they might just ignore your cease and desist letter because they know at some point, if you do want to sue them, you're going to get an attorney to do it. And that attorney is going to send you a cease and desist letter. So there likely isn't any harm to them by ignoring your letter. They figure it makes more financial sense to them to ignore your letter, just hoping it'll go away, than it does for them to respond to you and make any kind of offer, or even just to say that they don't think they're infringing. So I'm going to start real basic. You want to make this look as professional as you can. So you should have a letterhead with your name on top, put a date of the letter below that. In the part where you're addressing this to someone, find out who you're addressing it to. Maybe you have the legal department address of the company. You might address it to the CEO. At some point, it's going to end up in the legal department, so I would try to find out the address of the legal department, or if not, you can address it to the CEO. Also, write on there how you're sending it. Are you sending it just by email? Then you should write via email. I would recommend sending it by email and also by certified mail. So write via email and certified mail. Below that, I like to put RE, and I might say RE, infringement of patents by, and then your name. Below that, you start your letter. Say dear, and then the CEO's name. In the body of the letter, the first paragraph might say something like, I'm John Smith, manufacturer and seller of a well-known and commercially successful avocado slicer. If you've listened to my earlier podcast in the series, I talked a lot about avocado slicers. So I'm just pretending that your invention that you have a patent on is for an avocado slicer. You might say something like, as you're likely aware, I own intellectual property covering the avocado slicer. And then you might want to put in the brand name or product name that you're selling it under, including the patent for the avocado slicer. If you also own trademarks or copyrights, I would say that too. Then after that, say, the purpose of this letter is to address your continuing infringement of my patent rights. That's your intro paragraph. The next section, you might want to have a header that says patent infringement, especially if you're going to have multiple sections such as trademark infringement and copyright infringement. If you're only going to talk about patent infringement, then you don't really need to label this as a separate section. Now, here's an example of what you could write. I'm the owner of U.S. patent number, and then write what that patent number is, which issued on, and then write the date that it was issued, entitled, and put the title of your patent. If you have more than one patent, then list them all here in this paragraph. Then write, a copy of this patent is attached to hereto as Exhibit A. Now, at the end of this letter, you'll want to have a page that says Exhibit A, and then after that page, you'll provide a copy of your patent. Then you might want to say something like this if the avocado slicer was the issue. The patent claims an avocado slicer that has A, a splitting blade, B, multiple slicer blades, and C, a pitter. I mean, obviously, you'll put in whatever's in your claims. And you probably want to look at your claims and put in exactly what your claims have and list them exactly or nearly exactly as you have them in your claims. What you might want to do next is say something like, these features are shown in annotated figure 1 of the patent below. Now, what's useful to do is take a figure from your patent and draw or write annotations on it and point to the different parts that were in your claims. Make it real easy for the person reading this to see what your claims are and what kind of products it might cover. You can then put in a section about your sales. You might say something like, since at least as early as January 2018, I have sold in the United States an avocado slicer under the avocado slicer brand. Put in whatever name you're selling it under. Let's just call it ASB brand, standing for avocado slicer brand. Photographs of the ASB brand avocado slicer are shown below and annotated to show the salient claimed features. Now you want to go into what the other company has been doing. Let's call this company IPC, standing for Infringing Product Company. Not too creative, but it works for the sample. You might write something like this. I have recently learned that IPC is marketing, selling, offering to sell, and or importing into the United States an IPC avocado slicer under the brand name IPC avocado slicer, model number X. Now put in whatever model number you have for their product if you have it. The IPC avocado slicer includes the patented features of my patent. Then you'll say what their product has. The IPC slicer has a splitting blade, multiple slicer blades, and a pitter. Please see the annotated image below. What you'll do is have a photo of their product and annotate it, showing those same elements that are the same as what you got a patent for in your claims. Then say, therefore it appears that my patent is being infringed by IPC's marketing, sale, offering for sale, and or importation of the IPC avocado slicer product. I demand that IPC immediately cease and desist from any and all making, using, marketing, selling, and or offering to sell the infringing IPC avocado slicer product. As this letter serves to put IPC on notice of its unlawful, unauthorized, and infringing acts in all regards to my valuable intellectual property, any attempts to make, use, market, sell, and or offer for sale the IPC avocado slicer will constitute willful infringement by IPC, and thus provide grounds for me to seek treble damages in the event litigation is necessary. I await your prompt response. In the meantime, if you have any questions, please feel free to contact me. Sincerely, and then put your name and signature. Then, as I mentioned before, you'll have a page marked Exhibit A, and you'll put your patent. That's basically it for a bare bones patent infringement cease and desist or demand letter. This only serves as an example. Your letter might need to be very different depending on what results you want. Now, a few notes about why certain things are in this letter. There's a section where I mentioned notice and willful infringement. Let's say that you've calculated this other company owes you $1 million because you lost $1 million in profits due to people buying this other product instead of your own product. Normally, you would just get $1 million in damages. But if the other party willfully infringed your patent, you're allowed to get up to 3 times that, so $3 million. What you're saying in this letter is that you've put them on notice of your patent, and that if they are continuing to sell their product, then they are willfully infringing your patent, and could be up to 3 times what would be the normal amount. See, it's possible that this company had no idea your patent existed. They would still owe you $1 million, even if it was done totally innocently. But if they knew about your patent and decided to copy your product anyways, that's a willful infringement, and there's extra monetary punishment for that. So that's why it's good to have a sentence in your letter about that, because it might scare them a little bit more into stopping them from selling their product if they know that they'll owe 3 times as much money as what they normally might owe you in a lawsuit. You do have to be careful about one particular thing with cease and desist letters, and that has to do with the strategy about if your case ends up in court, which court it will be. This is what can happen, so be careful and also discuss this with your attorney, because if you send a cease and desist letter to someone or a company that's not in your state, you may end up having to go to court in their state, not your state. So if you're in California and you send a cease and desist to someone in New York, the lawsuit might end up being in New York, and you have to go all the way to New York to try your case. You probably don't want that. You probably want to stay where you are and have them come to California. This is because when you send a demand letter, you've created a controversy. And when you've created a substantial controversy, the other party can ask a court to decide the controversy. And they might take you to a New York court and invalidate your patent because you threatened to sue them. This is called declaratory relief. When someone is reasonably threatened with the lawsuit, you can go to the court first and ask for declaratory relief under what's called the declaratory judgment jurisdiction. Now, courts have said that if you've threatened to sue someone, you can expect that you could be sued in the state that you sent it to. Now, some might argue that if instead your letter wasn't very aggressive and it just said, hey, this is my patent, do you want to examine your line of products to see if any of them are covered by my patent, and we can enter into a licensing agreement, then maybe that's not enough for the other party to ask for declaratory relief. But cases now say that it might be enough. There's no black and white answer on what's enough for a party to sue you first in their own state if you send them a cease and desist letter. The court is going to look at what's called the totality of the circumstances. Do you have a relationship with this party? What is the litigation history that you have? Do you often go around suing people after sending just a request a license? All these things will be taken into consideration in the totality of circumstances test. But what's in the cease and desist letter is going to be one of the key factors. If in your letter you had detailed patent infringement charts, that's an indication that you plan on enforcing your rights. In the sample that I gave in this episode, if you provide annotated pictures, that kind of leads in favor of you planning on enforcing your rights. So in some situations, you might not want to go into all those details. However, there was a case that said that merely identifying your patent isn't enough for a concrete dispute. So you can probably reference your patent number in a cease and desist without that triggering by itself declaratory judgment jurisdiction. But as I said, it's going to be a totality of the circumstances test. So you want to be strategic in sending a cease and desist letter, and you should be prepared to litigate in the states where you send that letter. And on the other hand, if you receive a cease and desist letter, you should think about whether you want to sue in your own state or a different state. Most of the time, you might think it's just best to sue people closest to your home because it's easier for you. And that might be one factor, but there are some regions in the United States that are known to be more patent-friendly for patent owners and others that are less friendly to patent owners. So you'll want to discuss this with your attorney on the best strategy and which courts to use if you end up suing someone, and also the best strategy and how you want to word your cease and desist letter to have a better chance of the outcome that you want. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamentpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamentpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.